Good afternoon. Welcome to the regular meeting of the Business, Housing, and Zoning Committee for January 30, 2024. I'm Jamal Osman, and I'm the chair of this committee. At this time, I'll ask the clerk to call the roll so we can verify a quorum for this meeting.
Councilmember Rainville,
Present.
Cashman,
Present.
Jenkins is absent. Chowdhury,
Present.
Vice Chair Ellison,
Here.
Chair Osman.
Present.
There are 5 members present.
Let the record reflect we have a quorum. The agenda for today's meeting is before us. We have 7 items on consent agenda. The first item is 9 liquor license approval. The second item is 3 liquor license renewal. The third item is 3 gambling license approval. The fourth item is accepting a grant from the Minnesota Historical Society for Minneapolis African American History, Historic and Cultural Content Study. The fifth item is mayoral appointment and reappointment to the Minneapolis Art Commission. The sixth item is setting a public hearing for February 13 to consider reappointment of Joseph Campbell to the Planning Commission. The last item is setting a public hearing for February 13 to consider 2 council reappointments to the Zoning Board of Adjustment. Is there any discussion on the consent agenda, or are there any items that anyone would like to pull for further discussion? Seeing none, I will approve of the consent agenda. All those in favor say aye.
Aye.
Those opposed say nay. The ayes have it, and the motion carries. I just want to note that we have been joined by Councilmember Palmisano. There's an item from her ward that's on the agenda that we'll get into. Our next item is public hearing for on-sale liquor with no live entertainment with Sunday sales for a stepchild. I'll ask Akbar Mohammed to give us a presentation.
Thank you, Chair Osman and committee members. I am Licensed Inspector Akbar Mohammed, Licenses and Consumer Services. I'm presenting the application from Stepchild LLC. DBA is Stepchild, located at 24 University Ave Northeast, Unit 100 in Ward 3. Current license is an on-sale wine, no live entertainment with strong beer. The applicant is requesting an on-sale liquor, no live entertainment with Sunday sales. Stepchild has been operating at this location since spring of 2021. They have 44 indoor seats and will be open daily from 5 p.m. to 10 p.m. Due to a clerical error on public hearing notice, it stated exterior hours, but that was incorrect. This license will only cover the interior. On January 17th, public hearing notices were sent to the property owners within 600 feet of the premises. Notices were also sent to Nicollet Island Neighborhood Association and the Northeast Chamber of Commerce Business and Council Member Rainville. We have received 2 comments via email from the community. 2 support this application, 0 were opposed, and there are no concerns. The Licenses and Consumer Services Division recommends approval of an on-sale liquor, no live entertainment, with Sunday sales for Stepchild. That concludes my presentation. At this time, I will stand for any comments or questions. Thank you.
Thank you so much. Are there any questions? Councilmember Rainville.
Thank you, Mr. Chair. And what time would the liquor sales end at, please?
I believe 10 p.m.
Okay, thank you.
Thank you so much for that presentation. I'm going to proceed to open the public hearing. I'll ask the clerk if anyone has signed up to speak.
No, Chair Osman, no one has signed up to speak.
Did not sign up to speak and wish to speak, please let me know. Seeing no one else willing to speak or wishing to speak on this item, I will close the public hearing. Oh, go ahead, sorry.
No worries, I didn't know how this worked.
Thanks for having me here. I'm with the Stepchild LLC restaurant in Northeast Minneapolis. We've been open for 3 years. 4.6, 4.7 stars. The only one of the main grievances we get from customers is that we don't have a full liquor license. So, if you guys pass this motion, we'll be able to serve our neighborhood with a full liquor license. And to clarify, we're closed at 10 p.m. on the weekdays, and then on the weekends we're open till 11. So, but yes, thank you.
Thank you so much. Is there anyone else? Seeing none, I'll close the public hearing and call Councilmember Rainville.
Thank you. It's my pleasure to move forward item number 1 for approval, please.
Thank you. With Councilmember Rainville motion, all those in favor say aye.
Aye.
Those opposed say nay. The ayes have it, and the item is approved. On the next item is a public hearing for on-sale liquor license, no live entertainment, and Sunday sales license for Waterbury. I'll ask Joseph Olson.
Thanks, Chair Osmond. Committee members. I'm Joseph Olson, Inspector with Business Licenses and Consumer Services. I'm presenting an application today for the Waterbury Restaurant. This is owned by Elevage Management Group, LLC, and is located at 3012 Excelsior Boulevard in Ward 7. The Waterbury is located on the ground floor of a brand-new residential development called the Waterbury House. The Waterbury's applied for an on-sale liquor license with Sunday sales and no live entertainment. The Waterbury features 85 interior seats with a private exterior patio at 20-seat capacity. The proposed hours are 7 to 10 p.m. I think that may change to 8 to 11 daily, but that's up in the air right now. Notices were sent to property owners within 600 feet of the premises, and also sent to the Uptown Association, to the West Makaskab Neighborhood Association, and to Council Member Katie Cashman. We've received one comment from the public in support of this application, and there have been no complaints, 311 calls, or police calls associated with this business. The License and Consumer Services Division recommends approval of on-sale liquor license with Sunday sales and no live entertainment. This concludes my presentation. At this time, I'll stand for any comments or questions. Thanks.
Thank you so much for that presentation. And now I would like to recognize Councilmember Jenkins, having joined us in the meeting. All right, I'm going to proceed to open the public hearing. And I have one person sign up. If you would like to sign up, please see the clerk. I will call Corey Burstad. I'm sorry, what were the names?
Thank you, Mr. Chair and Council. I am actually the owner of Elevage Management, Elevage Hospitality, also a part owner of the Waterbury House. We're excited to come to the neighborhood. We have several locations throughout the Twin Cities. We own and operate also like the Laurel Hotel in Stillwater. We own and operate Oliver's in Shoreview, Oliver's in Blaine, just for some kind of newer restaurants that we've done. This will be our 9th location. We have a little over 350 employees in our organization. We're excited to be part of the neighborhood. This is our first endeavor in Minneapolis. So through the process, working with Joe, I just want to give a shout out to Joe. It was a very good and very smooth process. As someone, each city is different, but just wanted to say thank you. We look forward to serving the neighborhood, and we're very proud of the Waterbury House and what we've built there in this small little patch of land. So thank you. Any questions?
Thank you so much. Is there anyone else? I'll close the public hearing and ask if there's any questions from council members. Councilmember Cashman.
Thank you so much to the Waterbury House folks for being here. Really excited about the new building. It's absolutely beautiful. great view of the lake, and folks in the neighborhood are really excited about having this new restaurant open. I was wondering if you could answer what's the timeline for opening if this is approved?
Councilmember, the projected opening time should be sometime at the end of February. Given the timeline that Joseph has given me, we'll just kind of follow along, and then with our hiring and stuff, we expect to be open by the end of February. I believe we have a private event scheduled already to start off on February 20th, so we should be shortly right after that. So,
Thank you.
Thank you.
Thanks for being here.
Thank you. Councilmember Cashman, would you like to make a motion?
Yeah, I'll motion to approve this.
Councilmember Cashman, motion to approve. All those in favor say aye.
Aye.
Those opposed say nay. The ayes have it, and this item is approved. Our next item is a public hearing to confirm 2 mayoral appointments to the Planning Commission. I ask Kimberly Holeen to give us presentation.
Good afternoon, Chair Osman and council members. The mayor is proposing to appoint 2 new members to the City Planning Commission. Kelly Jones and Tom Wagner are both proposed to be appointed to 2-year terms. They're here today. I don't think they necessarily need to say anything. I know we've got a pretty long agenda today, but staff is recommending that the committee move their appointments forward.
Thank you so much. Thank you for your presentation. I would also like to offer my personal thanks to both nominees for your willingness to serve our city and your fellow citizens. I'm going to proceed to open the public hearing. Is there anyone that would like to speak? Seeing none, I will close the public hearing and ask if there's Councilmember Jenkins.
Thank you, Chair Osman, and I just wanted to welcome Kelly Jones back to the city. I had an opportunity to work with Kelly over a long time, let's just put it that way, and it's great to see you coming back to serve on the Planning Commission. Thank you, Chair.
Thank you so much. Is there any other comments? Councilmember Chowdhury.
Thank you, Chair Osman. I just wanted to welcome the 2 individuals as we move forward into approval. I'll be serving on the Planning Commission too, and so I would love the opportunity as an appointee from the City Council to grab a cup of coffee. I know that Tom Wagner is also a Ward 12 constituent, so I'm excited to see these appointments be made and all the work that we'll do collaboratively together to improve our city.
Councilmember Rainville.
Thank you. I too want to echo the praise of Kelly. I think we met about 30 years ago, and I was impressed with you on day one, and so thank you for volunteering your time on those long Monday nights.
Councilmember Allison.
All that praise, and I don't think anybody's moved approval, so I'll go ahead and move approval of these appointments. And again, Mr. Wagner, thank you for serving, and Kelly, it's great to see you. So thank you all.
With Councilmember Allison, motion to approve. All those in favor say aye.
Aye.
And those opposed say nay. The ayes have it, and this item is approved. Now, our next item is an appeal regarding a certificate of non-conforming use at 1501 Johnson Street Northeast. I'll ask Alex Kohlhaas to give us a presentation.
Thank you, Chair Osman and members of the committee. My name is Alex Kohlhaas. I'm a planner from CPED's Planning Division. Before you today is an appeal of a decision of the Zoning Board of Adjustment denying a certificate of nonconforming use for a motor vehicle storage lot at 1501 Johnson Street Northeast. This comes from the November 9th, 2023 Board of Adjustment hearing. I'll go over a lot of the background as was presented to the board and was the basis of their decision. Then I'll also touch on some of the specifics for the appeal as relevant. So just to provide some kind of zoning code background before we get to the details for this application, you may be familiar with much of this already, but this is a portion of the use table in the current zoning code, which was adopted last July. This is relevant when we are considering a certificate of nonconforming use. For zoning purposes, when we talk about uses of property, we are talking about uses as delineated in the zoning code primarily. This includes some high-level use categories like production versus commercial versus residential, et cetera. And then within each of those are more specific use groups. And I've highlighted a couple of relevant ones here. So towards the middle is a warehousing and storage use group. And then within that is an individual use as a contractor's yard. And then towards the bottom within our transportation use category, there is a vehicle storage use group. And then that can also have specific uses within that. In this case, a motor vehicle storage lot use is specific use within the vehicle storage category. And on the right-hand side towards the bottom, you can see there's some more language that kind of describes these different use categories and uses. And these might have different standards that apply to each of these. For zoning purposes, this is what we are looking at when talking about uses of properties. Some of these uses have specific definitions, but there are others that aren't explicitly defined for zoning purposes. In that case, the zoning code provides that they shall have their common meaning. So for a certificate of nonconforming use, I'm not going to read through this, but just to paraphrase where this is coming from in the zoning code, this is from our current zoning code, but we have language like this going back to at least 1963. A nonconforming use of a property being something that is not permitted in the zoning district that the property is located in. A legal nonconforming use is when it was lawfully established at some point in the past, when it was allowed by the code at that time. Then the zoning code changed to no longer allow that use in that zoning district. A legal nonconforming use can remain as long as it's in continuous lawful operation after that point and is not expanded, et cetera. Rights to a legal nonconforming use run with the property, so even if there is a change of tenant or a change of ownership, if it's the same underlying use that's continuing, then those rights carry forward. If a nonconforming use is discontinued for a period of 1 year or more, then those nonconforming rights are lost, and all subsequent use of the property must be in compliance with the zoning code in effect at that time. If there is a dispute about the legality of a use of a property that's not permitted in the district that the property is currently located in, then the property owner or other interested party can apply for a certificate of nonconforming use. This is not subject to the same required legal findings as other types of land use applications. The zoning code has a specific language about when a certificate of nonconforming use can be granted, and that is when the applicable board, commission, or council establishes that the use is legally established on the subject property and has retained legal nonconforming rights. If the applicant does not establish the required facts, no certificate shall be issued. Where the loss of nonconforming rights is apparent due to a vacancy, the property owner may rebut the presumption of abandonment only by presenting clear and convincing evidence that the discontinuance, of the nonconforming use for the specified period was due to circumstances beyond the property owner's control, and the property owner shall bear the burden of proof. I'll note if the use of a property is changed to a conforming use, then those nonconforming rights are lost. And if you have a legal nonconforming use of a property, you can't just change to another nonconforming use without coming to the city for approval. Change of nonconforming use requires another type of land use application, including public hearing and approval by the City Planning Commission. So with all of that background provided, thank you for bearing with me. We can turn to the property at hand. This is 1501 Johnson Street Northeast. It is an irregular parcel that's roughly teardrop shaped. It has a lot area of around 97,000 square feet. There is a 1 to 2 story building on the property, a paved parking area near the street, and then the remainder of the property is largely unpaved. This is located in the middle of a lot of different types and intensities of uses, where there's I-35W right next to this. There is a northwest athletic field park across the street. The quarry is nearby, and there's a couple of low-density residential neighborhoods here. Historically, the principal use of the subject property was as a contractor's yard from 1990 through at least 2018, but the use of the property over time and up through today is directly related to this appeal, so I'll come back to that in a few minutes. The current owner of the property is Minneapolis Park Property LLC. They were the applicants for the certificate of nonconforming use and are now the appellants. They are managed and represented by Dale Zorb. This is a private entity without any known affiliation to the park board. It's just a similar name. The subject property was previously owned under a separate entity called Building Restoration Corporation, which is also managed by the same Dale Zorb. The current zoning map of the property, you can see it's currently in the CM2 Corridor Mixed Use Zoning District and the Transit 10 Built Form Overlay District. Immediately prior to this, which was a result of the city's new zoning code and map from July of last year, this was previously in the I-1 Light Industrial Zoning District. Just to go through some of the relevant property history, I don't want to belabor this, but again, to set the groundwork for the decision that was made by the board, and this is the information as it was known going into that board hearing back in November. So going back to 1963, this property was in a different light manufacturing zoning district at the time, which included storage of materials, goods, or products as a permitted use, and it also allowed a contractor's yard as part of a combined use with contractors' offices and shops. And then in 1990, the property was purchased by the applicant as Building Restoration Corporation for use as a contractor's yard, as well as motor vehicle storage and outdoor storage, to quote a portion of their application materials. And a contractor's yard was also permitted in that M1-2 district. Contractor's yard is not explicitly defined in the 1963 zoning code, but we did add a definition in 1999, and that continues through to today. A contractor's yard use for zoning purposes in Minneapolis is defined as an establishment providing general contracting or building construction services, and which involves outdoor storage of machinery or equipment. So the presence of outdoor storage is a defining feature of a contractor's yard use. It is inherent to that use. So when a contractor's yard is a principal use of a property, the outdoor storage or any outdoor storage that takes place is inherent to that use. Then moving forward to 1999, we adopted a new zoning code and zoning map at that time, and the property was rezoned into that I-1 Light Industrial District. Contractor's yard was not a permitted use in the I-1 district, so that use, which was legally established almost 10 years prior, became lawfully nonconforming and was allowed to continue as long as they remained in continuous lawful operation. Fast forwarding again to April of 2018, going into the Board of Adjustment hearing this past November, our understanding was that April of 2018, that was the last date that we could see that contractor's use had been continuing through. And so then 1 year after that, in April 2019, was when we saw the expiration of those non-conforming rights to a contractor's yard use. And this is a photo provided by the appellant showing the use of the property around that time. Then in December of 2022, the appellant's attempted establishment of a use of the property as what staff has determined is a motor vehicle storage lot use. And you can see, again, a photo of the property from last year. This involves a lease to a tenant 11th Hour Recovery LLC for use as general office, sales, repair shop, and outdoor storage. The appellants also described this use of the property as an asset repossession service, which collects vehicles that have been repossessed and stores the vehicles at the property until they are driven to auction or picked up by the owners. Again, staff determined that this is not a contractor's yard use. This is a motor vehicle storage lot use, which was not permitted in the I-1 zoning district that applied at the time in December of 2022. And then just to close the loop on the history, last year this was rezoned to the CM2 district, which also does not allow a motor vehicle storage lot. So again, just to bring up the same use table and again highlight that these are two different uses in the zoning code. They have different descriptions. One of them has an explicit definition, and we don't find that the non-conforming rights to a contractor's yard extend to a totally different use for how we classify it for zoning purposes. Just to go through a couple of the other findings that were articulated in the staff report that aren't explicitly covered by the property history. Staff found that the applicant has not demonstrated that discontinuation of non-conforming contractor's yard was entirely outside of the property owner's control. Finding number 7, after the non-conforming rights appeared to expire in 2019, subsequent use of the property was limited to as allowed by the zoning code at that time. I mentioned a motor vehicle storage lot not being a permitted use in the I-1 or CM2 zoning districts, and then to reiterate those required components of an approval for a certificate of non-conforming use, that the property owner bears the burden of proof. And from staff's perspective, the available evidence does not factually establish that the motor vehicle storage lot use was lawfully established. So this was a staff analysis that went to the Board of Adjustment, and which they ultimately adopted in their decision to deny this certificate of non-conforming use. Just to conclude quickly, for some additional evidence that's been presented as part of this appeal, and there was some materials that the appellant did not include in their original variance or their original certificate application that they brought to that Board of Adjustment hearing. So some of this might have been heard, and then they provided additional documentation after the Board of Adjustment hearing with their appeal. This includes some additional lease records, some property photos and checks. Besides what I've shown today, this should all be available as part of your packets for today. Just to give you the highlights there for the relevant portions, I think include description of a concrete pumping or contracting company that's been operating starting, I think, in March of 2017 into at least last year. We also describe some various extensive building restoration corps' continued use of the property, mostly for storing a single semi-trailer on the 35W side of the property for advertising purposes. There's an affidavit from the appellant that attests to building restoration corps' continued use of the property as a contractor's yard. Again, from staff's perspective, we still see the use of the property as evidence from when this first came to our attention almost a year ago. We still see this as a motor vehicle storage lot use in terms of how at least portions of the property are being used today. And we don't see any conclusive evidence of ongoing non-conforming rights to that use. So in conclusion, staff recommends denial of this appeal. I will note that if it were determined that ongoing non-conforming rights for another use, such as a contractor's yard, remained in effect for this property, then the appellants could apply for a change of non-conforming use, which requires a public hearing of the Planning Commission if they did want to pursue approval of changing a non-conforming contractor's yard, for example, to a motor vehicle storage lot. The appellants and their representatives are in attendance today. This concludes my presentation, but I'll stand for questions.
Thank you for that presentation. Are there any questions from members? Thank you, sir. I'm going to proceed to open the public hearing. In quasi-judicial hearing, we hear the first from the appellant. I will allow appellant up 10 minutes to address the committee. And I'll call Dale Zorb, or representative, to take.
Thank you, Chair Osmond and members of the Business Housing Zoning Committee. Thank you for your service to the city. My name is Dale Zorb, and I'm the manager of Minneapolis Park Property, LLC. To be clear, we are trying to confirm only our grandfathered non-conforming use of the property as a contractor's yard. And given a few medical issues related to my throat, I'd like to ask if I can present my verbal statement with a pre-recorded video that's 10 minutes long, including the relevant exhibits that show continuous use of the property.
Yes, you might proceed. Question for Councilmember Ellison.
My understanding is that the presentation has 10 minutes total, and so if the video is 10 minutes, you're already down to 9? Yeah. Okay, so just wanted to, 7, not 10. Got it, sorry.
Members of the Minneapolis City Council, my name is Dale Zorb, and I stand before you today in this 10-minute video as a concerned business owner and local employer who has always strived to be a responsible steward of my property, to create employment opportunities and to contribute to the economic well-being of our community. Throughout the years, I've worked diligently to adhere to every rule and regulation, all while endeavoring to make our neighborhood a better place through economic prosperity. Please let this video serve as my statement to formally appeal the decision rendered by the Zoning Board of Adjustment during the hearing session on November 9th, where our application for a certificate of nonconforming use for the property located at 1501 Johnson Street Northeast was regrettably denied. Our original application of nonconforming use submitted in September of last year was missing some important evidence to support our claims. But since then, we've been able to provide almost 4 times as much evidence to support our position, including copies of leases, invoices, and checks that attest to the use of our property as a contractor's yard each year. Despite providing the City Department of Planning and Economic Development with ample documentation and evidence supporting our case in November of last year, however, the city has refused to amend their recommendation even after reviewing our appeal and the new evidence, which clearly demonstrates the continuous use of the property as a contractor's yard. In any court of law, the evidence we presented would be considered more than sufficient to overturn the initial decision. Now let's get straight to the point. The denial by the Zoning Board of Adjustment, influenced by Chair Matthew Perry, seems to disregard the compelling evidence we provided. Perry's reluctance to acknowledge the evidence and his refusal to consider bifurcating the property's use raises questions and concerns about bias toward a blanket denial. Presently, we seek a certificate of nonconforming use for 1501 Johnson Street Northeast, aiming to uphold our rights as property owners. This property has played a vital role in our lives and has been an indispensable asset for our businesses. Formerly owned by Building Restoration Corporation from 1990 to 2016, the property has been held under Minneapolis Park Property since 2016. With the use of the property, BRC has been able to restore numerous buildings in Minneapolis, including this very City Hall in 2020. As you know, from 1990 to 1999, the property was zoned as M1-2, allowing for the operation of a contractor's yard, inclusive of vehicle and outdoor storage. However, a zoning change in 1999 reclassified the property as I-1, eliminating the allowance for a contractor's yard and associated storage. Despite this change, the property's usage was grandfathered into the new zoning regulations, granting the right to maintain existing uses. The continuous use of this yard for outdoor and vehicle storage has persisted since then, each and every year, as evidenced herein. In December of 2022, as manager of Minneapolis Park Property, we entered into a lease agreement with 11th Hour Recovery, Inc., an asset repossession service. This company temporarily stores repossessed vehicles on their property until they are auctioned or claimed by their respective owners. Importantly, these vehicles typically remain on the property for less than a week. Furthermore, the property continues to be utilized for storing contractors' equipment, machinery, materials, and trailers, including those of BRC. The flexibility provided by the Minneapolis Code of Ordinances allows the nonconforming use to continue without interruption, irrespective of the changes in property ownership or management. Therefore, the outdoor storage on this property remains a legally protected nonconforming use that can be passed on to future property owners. Now let's address the city's findings. Respectfully, we dispute finding number 5, as evidence provided herein contradicts the city's claims of discontinuation. Lease agreements, financial records, and photographs attest to the continuous use of the property as a contractor's yard. Finding number 6, regarding the discontinuation beyond a 1-year period, is challenged by our evidence. And finding number 7, about the expiration of nonconforming use rights, is refuted by the comprehensive evidence we've presented, seen with this video presentation. Finding number 8 attempts to draw a strict distinction between a motor vehicle storage and a contractor's yard. We argue that this distinction is invalid, given the lack of a clear definition in the city code. Finding number 8 attempts to draw a strict distinction between a motor vehicle storage and a contractor's yard. We argue that this distinction is invalid, given the lack of a clear definition in the city's code. The city even admits to this unclear distinction within the current code in their November 9th presentation packet. The city is contradicting its own interpretation and the prior interpretation of the code. By definition, contractors need vehicles and equipment to operate. Additionally, there is no clear definition within the city code, so the interpretation cannot be fully subjective. If the city decides that a motor vehicle storage is not allowed in the contractor's yard, then it would mean that a contractor could not store any of their equipment, trucks, or trailers. Again, let me be clear. Our application is not limited to a motor vehicle storage lot. It is an appeal to certify the legal nonconforming use of a contractor's yard. This broader interpretation aligns with the property's history and the practicalities of a contractor's operation. During last November's hearing, the board seemed inclined to grant the certificate for the contractor's yard usage. However, Chair Matthew Perry's skepticism influenced a denial. Board member Sally Granz-Korish acknowledged within the hearing that she regularly passes by the property and observes BRC's trailers on the premises along with evident contractor activity. Despite this acknowledgement, the board as a whole appeared reluctant to fully recognize the substantial quantity of the evidence presented. We urge the council's approval of the certificate of nonconforming use for a contractor's yard, acknowledging the property's rightful status. We want to work together with the city to find an amenable solution so the city does not have to waste taxpayer funds in a court of law. Such a decision would demonstrate the city's commitment to adhere to practical interpretations of the codes, industry practices, and prior legal precedences. Thank you. Any questions?
We don't take questions, but you have 2 more minutes if you want to share more additional information, or we can move on.
Well, I just wanted to be clear that we're only asking for our grandfathered rights as a contractor's yard to be maintained. And so we're asking for a non-conforming use for a contractor's yard is what we're asking for. And if you have any questions, I'll certainly answer them.
Thank you so much, sir. Next, we will hear from others who have signed up to speak. You will each have up to 2 minutes to speak. I will remind you that you are required to limit your comment to arguments specifically addressing the legislative record in this matter. And I have a list here. Todd Smith. Start here. Is there anyone else who would like to speak? Are there any questions from these members? Councilmember Jenkins.
Excuse me, Chair Osmond, you may want to close the public hearing.
Thank you. All right, seeing no one else to speak, I will close the public hearing, and Councilmember Jenkins.
Thank you, Chair Osmond. I'm just curious how this came to attention. Is there some public concern that is being addressed? Are there complaints from neighbors? I'm not sure why.
If you allow, Chair
Yes,
Osmond, Councilmember Jenkins, this did originally come through zoning enforcement. I believe we did receive a complaint, and this came originally enforcement started back in March of 2023, I believe, when the property owner was notified. There is a little bit of discussion, including with the zoning inspectors and city staff, about what uses were identified as taking place at the property, and discussion of potential opportunities to come into compliance with the zoning requirement. And this application for a certificate of nonconforming use is one such potential pathway towards bringing the property into compliance.
So is there a distinction between trucks and construction vehicles versus automobiles?
I think for zoning purposes, if it is really parking and storage that is associated with another principal use on the property, like a contractor's yard, then we can easily consider that to be part of that use. If all they are doing is parking vehicles that is not related to another principal use on a property, and if they're parking, passenger vehicles, not just sedans, but SUVs, pickup trucks, or if they're parking larger vehicles on a property and that is the only use, is just the storage of vehicles, and it's not directly tied to another use on the property, then that's a situation where we would classify it as a motor vehicle storage lot use.
So, I mean, they're not using it as a parking lot where they're generating revenue, et cetera.
Correct. That's my understanding, is that this is not like a pay parking lot. It is used in conjunction with a company that repossesses vehicles and stores them on this property until they are moved to another location, depending on what is happening with those individual vehicles. That's my understanding of the use of the property at question here.
Thank you. And then for clarity, so Mr. Zorb in his video provided documentation seemingly of continued use. Was that not available at some point in time, or?
Much of the documentation that was available in your packets, and I can't speak for every single item that was in the video. Much of that was not available to staff and the members of the Zoning Board of Adjustment prior to that Board of Adjustment hearing. And then there were a number of additional documents, including leases, photos, checks, et cetera, that were provided after that Board of Adjustment hearing was made to deny their application and as part of their appeal. So as staff, we did look at that documentation, we did consider it. We can't go back and change the staff recommendation to approve a certificate of nonconforming use for a motor vehicle storage lot because he is appealing a decision of the Zoning Board of Adjustment. And also there, from staff's perspective, is still this distinction between whether or not there is documentation to prove ongoing nonconforming rights to a contractor's yard. We don't recognize any, or we don't see any proof that the motor vehicle storage lot use was lawfully established on the property. These are two separate uses, and even though there was past evidence of contractor's yard as a legal nonconforming use going back to the 1990s, if someone did want to change that, what eventually became a legal nonconforming use, to another use that's not allowed by the zoning code, that requires a change of nonconforming use application. But we don't really have any evidence to even show that the contractor's yard was continuously established up through today.
And do you recall what the original complaint was?
I don't recall off the top of my head the specifics. I believe it was something related to parking vehicles at this property. And regarding the use of the property.
Because it seems like the property is contained and away from, I mean, I think you know that there's some residential, there's a commercial property a little ways away, the quarry, I think you said. I'm not sure what problem this is causing, this non-conforming use.
Obviously, I can't speak for the complainant or what would have motivated them to submit that complaint. From staff's perspective, when this originally came to our attention through that complaint, it was located in the I-1 zoning district. Whether or not anyone thinks a motor vehicle storage lot is appropriate on this property, that was not a permitted use in that zoning district. And when the property was rezoned to CM2 last summer as part of the citywide rezoning, it's now in the CM2 district. It's also not permitted. So from staff's perspective, we don't have any authority to just say, this doesn't look like it's hurting anyone, so we should allow them to, because the zoning code explicitly prohibits this use in this zoning district.
No, thank you. I understand that. Can you define CM1, please?
The CM2 zoning district that the property is located in. It's, I believe, the corridor mixed use zoning district, which is primarily commercial in nature, but does allow some other non-commercial uses like residential, I think is common. I can't speak to how this property in particular was placed into that CM2 zoning district, but it was part of that citywide land use rezoning study that was adopted and went into effect last summer.
Okay, thank you very much.
Member Allison.
Just a few questions, just because I'm trying to clarify, and I know usually, at least in my experience with quasi-judicials, we don't take on new evidence, but here it was appropriate for the new evidence to come forward, and so it is clarifying. The one thing I'm struggling with is that I don't know that this body is equipped to determine whether that new evidence is verifiable, like fabricated. I'm not saying that it is. I'm just saying we're not equipped to know one way or another. And we've got the staff recommendation and the decision of the Zoning Board of Adjustments before us. But it strikes me that, am I correct in assuming that discontinued use is sort of the main thing that we're discussing here, right? If the discontinued use from 2018 to 2019 doesn't come into play, then they're sort of allowed to continue using the site in the way that they have been, minus the motor vehicles. Is that correct?
Chair Osmond, Councilmember Ellison, generally that's correct. Again, when I was walking through the history of the property, that was as we understood it going into that Zoning Board of Adjustment hearing, so that's notwithstanding the other evidence that the appellant has brought forward since then. So regardless of whether or not there is that discontinuation of the property, if they had continued the contractor's yard use all the way through till today, then they could continue to use as a contractor's yard use. But from staff's perspective, motor vehicle storage lot is a fundamentally different use of the property. You can have multiple uses of a property at the same time. So we wouldn't say that the fact that they have ongoing rights to a contractor's yard allows them to also use it as a motor vehicle storage lot.
Right. That's kind of what I was setting up, which is that there's the issue of the discontinued use and whether or not that occurred, but then there's this, and if we regard the new evidence as legitimate and we say, hey, look, this looks like it was continued, there's still the problem of the motor vehicle storage, which we would probably want addressed. And I guess I can direct the staff this question either to you or to the attorneys. If we're dealing with this problem where the body might find one element of the appeal legitimate, but the other element of the appeal non-legitimate, how do we sort of how could we make a motion to sort of recognize that, or is that possible in this instance?
Yes, Mr. Chair and committee members, I certainly understand your question. I actually might have a clarifying question or two for staff as well. It sounds like some additional evidence came in, as is permitted in these cases, specifically addressing the question of whether the use as a contractor's yard was continued or continuous or ever not interrupted for a year or a greater time. I think it would be important for staff to speak to their analysis of that evidence and whether you think it establishes that the use as a contractor's yard has been continuous. And then my other question is, I think it's clear that the principal use of this property right now is as a motor vehicle storage yard, but does the fact that possibly it has been continuously used at least as an accessory use or a small part of the property as a contractor's yard, and if that has been established, would that possibly lead to a result where the appeal should be granted, at least that the contractor's yard use has been continuous?
Chair Osmond, Mr. Fussy, if you'll allow me to answer those in the opposite order to your second question. If they are using a property with some principal use and then as an accessory use they are parking their vehicles and storing outside, from staff's perspective, we would not consider that a grounds to then recognize rights to another non-conforming principal use of the property. Perhaps they could apply for a change of non-conforming use to recognize another non-conforming principal use based on if it were found that the contractor's yard had ongoing and effective non-conforming rights. To your first question, I will say they have certainly provided a lot more evidence under the appeal than what was available to us before. Previously, we really had I could see no connection between that, I think, April 2018 date that I called out before and the present day demonstrating ongoing use as a contractor's yard. Now they have provided a bit more evidence, including some additional lease documents, copies of checks from their tenants, basically monthly or, relatively regularly, demonstrating the ongoing use in such a way, and additional photo evidence. So they did provide a lot more. That was part of a formal appeal application of a Board of Adjustment decision. So we were considering that as part of an appeal to the committee, if that answers your question.
So to this question of maybe the continued use did happen, but the motor vehicle storage is not an appropriate use. Is there a way for us to rectify that, or is that it? Or as the appellant said, is that a matter best left to the courts?
If you'll allow,
please.
I would defer to Mr. Fussy on any of the kind of legal analysis that might go into this. If there, obviously before you is this appeal specific to the certificate of nonconforming use for a motor vehicle storage lot. So however the committee would vote on that. If there's potentially a path to, say, notwithstanding staff recommendation or an approval in lieu of a motor vehicle storage lot, recognizing non-conforming rights to the contractor's yard use on an ongoing basis. I'm not sure if that's something that has ever been done before, or if there are any legal reasons why we should not entertain such a decision. If there was a decision regarding recognizing non-conforming rights to, say, a contractor's yard, then the appellants would still have a potential path forward for a change of non-conforming use from the Planning Commission.
Well, thank you. This conversation has been very helpful, and yes, we are looking at the motor vehicle storage use, not necessarily the storage yard use here, right? That's
the contractor's yard.
Contractor's yard. That's right. So I'm happy to move denial. I think that this has been this conversation has been clarifying, and happy to answer any questions from my colleagues about why I moved denial. But yeah, I'm going to go ahead and make that motion, and happy for further discussion.
Thank you, Councilmember Allison. Councilmember Jenkins.
Thank you. So, I guess for clarity, we are voting on the motor vehicle use that is currently occurring. Is there a way to consider the non-conforming use of the contractor's yard?
City Attorney.
Mr. Chair, committee members, and I would want to confer with staff, but I generally advise to keep the appeal or keep the question focused on what is before us. And it sounds like me the procedural posture of this is an appeal regarding nonconforming use specific to motor vehicle storage yard. If that piece, and if that is all that is in front of us, is that appeal is denied, I'm assuming that the appellant could bring a separate application to establish nonconforming use rights for a contractor's yard.
Chair Osmond, Mr. Fussy, that is my understanding as well. There are some limitations around how soon someone can submit the exact same application, but in this case, it would be a material different application for a different use, even though it would be a similar process.
Are there any other questions? Yes, Councilmember Chowdhury.
Thank you, Chair Osman. Just a clarifying question for me. If this denial was upheld today, what would be the tangible impact out of this committee and then to full council once it was ratified?
Chair Osman, Councilmember Chowdhury, all committee decisions are subject to a vote of the full city council at your next hearing. My understanding is typically that's not a public hearing, but obviously I don't mean to speak for the members of the council. And then those decisions are subject to mayoral signature and formal publication. Typically, that's the end of the process at the city for that specific application. If an appellant was inclined to pursue something through the courts, that would be a decision for them to make, or if there are other paths through the city, for example, a different type of land use application, either for a contractor's yard or whatever it may be, they could still have potentially other paths forward. Another thing I'll mention, this isn't quite to your question, but I'll say that when there is a dispute, for lack of a better term, about the use of a property, it doesn't always include or require a formal application like this. Oftentimes there are kind of informal, for lack of a better term, informal, if the evidence is very clear from the beginning that, a non-conforming use has been ongoing and was lawfully established, then the city can recognize those legal non-conforming rights without going through this process. This is when there is more of a dispute, for lack of a better term, about that evidence, and so that's why we're here, is because staff has not seen that connection so far.
Attorney Fuzzy?
Committee members, I think our staff has phrased that completely correctly. And I guess to summarize, if the motion on the floor to deny the appeal were to pass, there still would be other options that could be pursued if the appellant or staff were inclined to think that it's more appropriately designated as a contractor's yard.
Thank you so much. Are there? Yes, Councilmember.
If this appeal is denied today, then the motor vehicles have to disappear. They need to go away.
Chair Osmond, Councilmember Jenkins, the city would resume more active enforcement, for lack of a better term, and I can't speak for the deadlines that would come into play for that, but to your question, yes, generally we would expect the vehicles to be removed. The components of this that fall into that motor vehicle storage lot use, we would expect that to be discontinued.
All right, thank you so much. Seeing none, with Councilmember Allison's motion to deny appeal and stand with staff recommendation, all those in favor say aye. Aye. And those opposed say nay. All right, the item moves. Now, our next item is quasi-judicial hearing, is a certificate of appropriate appeal for 619 10th Street South. I'll ask Aaron, can't pronounce your first name, to give the presentation.
Good afternoon, Chair Osman and committee members. My name is Erin Kay, and I'm a planner in the Historic Preservation subsection of the Department of Community Planning and Economic Development, or CPED. I'm here today to present an appeal of two conditions of the Heritage Preservation Commission, or HPC, approval of a certificate of appropriateness application for the Hinkle House, which is an individual landmark located at 619 10th Street South. This HPC hearing was November 28th, 2023. I'll begin with some brief background on the property, summarize the application and the HPC's decision, and then explain the nature of the appeal. So here you can see the property's location in the Elliott Park neighborhood and a photo of the front elevation. The Hinkle House was designed by master architect William Channing Whitney and constructed in 1886 to 1887. The subject of this application is seeking approval for work that was already done to replace the wood fascia, which is located along the roof line, and remove wood brackets beneath the eaves due to rot and pest and rodent infiltration. So the brackets are the little small wood blocks you see under the eaves. On the left is a photo from 1890 of the house shortly after it was built. It looks relatively similar to how it has looked in recent years. In the top right corner is a photo from 1977, and in the bottom right corner is a photo from the 1990s. In both photos on the right, you can see a boxy fascia along the roof line, and then the brackets are either covered or had been removed. In 1996, the house suffered a serious fire, as you can see in the top photo. You can see that some of the brackets appeared to remain at that time. And then a restoration was undertaken, as you can see in the bottom photo, and it appears that the wood fascia and brackets were reconstructed. In early May 2023, the applicant submitted a building permit application to replace the shingles on the roof. Staff worked with them to do a preservation application, and the project was approved. As the roofing project got underway, the applicant determined that the wood along the roof line also needed to be removed and replaced. This type of work does not require a building permit, and so they did not know that they still needed preservation approval. And here you can see some photos showing the condition along the roof line that the applicant submitted. So you can see some of the deterioration here. And in doing their project, the applicant selected a metal fascia, as you can see here. Again, we're looking along the roof line to replace the wood fascia. They chose this material for its durability, resistance to moisture and pest damage, and low maintenance. The applicant also removed the heavy vines that had grown around the roof line, which can lead to wood deterioration and also create an inviting home for rodents and pests who then do further damage to the building. And here you can see a side elevation and the other side elevation. In staff's analysis of the project, we found that the change from wood to metal and the removal of the wood brackets did not follow the Secretary of the Interior standards for rehabilitation. Following these preservation standards, a more appropriate approach is to replace deteriorated features in kind, which means to replace the wood with wood. In this way, you can maintain the historical appearance and character of the building. In the HPC's review of the project, staff presentation, and testimony from the applicant, the HPC voted to adopt staff findings and approve the certificate of appropriateness subject to 5 conditions. The property owner submitted an appeal of 2 of these conditions of approval as listed here. This is essentially, the first condition is that the metal fascia has to be removed and replaced with wood or similar material, and that the wood brackets should be reconstructed as they were there before. In the appeal, the property owner identifies that because of the deteriorated soffits under the eaves, they've had a lot of issues with water damage and squirrels getting into the building. They determined that metal would be a better long-term solution than wood and would help maintain the building's condition in the future. They noted the cost of the work already undertaken as $70,000. If the committee chooses to grant the appeal, this would strike conditions number 1 and number 2 from the conditions of approval, which means the applicant would no longer have to meet these conditions. The committee does not need to develop new findings to support this decision. If the committee chooses to deny the appeal and uphold the conditions set by the HPC, then the applicant would work with staff to meet these conditions. Staff have received no public correspondence for this project since the application was noticed for the HPC hearing in November or for this hearing. I will note, however, that the process was initiated because staff were contacted by a member of the public who observed the completed work and expressed concern, and staff then directed enforcement staff to inspect and issue orders to correct. This concludes my presentation, and I'm happy to stay for questions. And the appellant, Michael Fay, who's the property owner, is also here and would like to make a few remarks.
Thank you so much for your presentation. I'm going to proceed to open the public hearing. We will hear the first from the appellant, Michael Fay. Please come. You have 10 minutes.
Good afternoon, Council. My name is Michael Fay. I am a local attorney. I own the Hinkle Mansion Murphy building, which I bought in 2012. I absolutely love the building. It's beautiful. I've done everything I can to keep it as beautiful and preserved as I can. It is very old. It was built in the late 1800s. We've had a lot of water damage, many roof leaks. We have a horrible squirrel infestation. We've had electrical problems because they come in and eat the wires, which creates a huge fire hazard. We paid over $70,000 to fix the roof. the wood is still going to rot. If we want this building to be there in another 130 years, we need to make sure that we approve it. I would never put something on this building that I didn't think looked good. The whole intention to put the metal is to preserve it and make sure it doesn't rot out and get damaged by wind and rain and wetness, and most importantly, the rodents. We don't have a few squirrels. We have hundreds of squirrels. It's a major problem, and we have to do something to stop it and keep the building there. So I don't know, it's just like Councilmember Jenkins asked in the last hearing, why we're here and who would make a difference, what difference this would make to people. I think we made it look beautiful. I think it preserves it. We spent a lot of money. I take pride in the building. I have spent a ton of time and redone a lot of the interior on it as well and make sure I've kept it up. So we would ask that the council deny those requests from the city and allow us to keep it as it is. Thank you.
Thank you so much. Are there anyone else who would like to speak? I see none. I will close the public here and ask. Oh, there's. Gotta look up. Thank you, sir. Please state your name.
My name is Ashley Ilvanen. I'm a principal of Alliance, a 130-person architectural firm in Minneapolis that serves the community. I provide design oversight for 2 design studios at my firm. I don't have a dog in this fight, but as an architect that is a firm believer in maintaining historical structures, I would, something to keep in mind relative to this appeal is that when you, and someone that knows, I'm an architect, I know how to detail things. When you put up metal fascias, you cover up the woodworks that's there. If it's rotten or in disrepair, you do not know if it's going to continue to rot underneath there. So relative to older homes, it's important to be able to see what's going on. So it would, and the historical character of the building is, these are significant details to the character of these sorts of houses. I just actually went through this exercise in my own residence in South Minneapolis, repairing rafter tails. If it's repaired right, properly maintained, properly flashed and detailed such the water runs off and not underneath, and painted, primed and painted, it will, you can maintain the integrity of that over a long period of time. It does require ongoing maintenance to paint it. In this case, with all the squirrels, I can appreciate that being problematic. Probably having vines on the house is not a good idea to encourage them to climb up to those levels of the roof. So that's my professional opinion. Thank you.
Thank you so much. Now I will close the public hearing, and if there's any other, yes, Councilmember Allison.
Thank you, Councilmember Osmond, or Chair Osmond. Just a few more questions for staff. Sorry, the public hearing is closed. Just a few more questions for staff. To the point that was made about, why do we care? Who's harmed? I think in decisions like these, I'm more focused on what potential sort of precedent this sets, what kind of slippery slope this sets for other properties where it might be a bigger deal or become a bigger deal. Is this, if we were to grant this appeal, would it sort of trigger any kind of, do we think it would trigger a precedent, set a precedent if we're trying to make decisions like this in the future?
Chair Osmond, Committee Member Ellison, thank you for the question. I will look to the city attorney to provide any guidance after I make my comment. But just in terms of these types of decisions that come before you, it's relatively common that we have appeals of some of these conditions that come before you. When an applicant comes to the HPC. Staff makes a case, the applicant makes their case, the HPC discusses. Sometimes they tweak conditions as written by staff. Sometimes they actually remove some, sometimes they add some. And then if the applicant doesn't like the conditions that have been sent, then they have the opportunity to appeal and come before you. So from my perspective, I am not concerned that if you choose to grant the appeal and you strike any conditions that would set any sort of precedent. I think it's pretty common in the practice that happens when you review these types of appeals.
And I would just echo those comments, Mr. Chair and Mr. Vice Chair of the committee. I would have no concerns about precedents. This is a very fact-dependent issue. It's a narrow issue on just a couple conditions. It's essentially, and just to kind of rephrase the decision that you have to make, because this is undeniably a historic resource, it's the applicant's burden to demonstrate that his proposal to address these two narrow conditions is necessary to correct an unsafe or dangerous condition, or that there aren't any reasonable alternatives to his proposal. So it's essentially weighing whether the metal versus the wood and looking at the vines and the squirrel issue and whether you think that's reasonable.
Thank you both. If there's no further discussion, or I know there's happy to make a motion, but I can wait until discussion is done.
Thank you. I just wanted to ask Mr. Fay, what is the use of the building? Do you live there? Is it an office? Is your law firm? What's going on there?
Yes, I house my law firm there. There is one other small law firm that rents one of the rooms, but principally it's just a business, and it's just my law firm that's there and my employees. And one other thing, we did completely replace the subfascia and soffits before we put the metal on there, so it's not like it's just rotting behind there like the architect had talked about. So that's it.
Thank you. Councilmember Allison?
Thank you, Mr. Chair. You can have a seat. I am, after hearing what we've heard, I feel like it is appropriate to grant this appeal and delete these conditions, and so I will move to remove these conditions and grant the appeal for item number 5.
Thank you so much, Councilmember Allison's motion to approve that bill. And thank the city attorney to draft staff finding. Is that correct?
Mr. Chair, I appreciate your remembrance of that important issue, but in this matter, because of the nature of it and the narrow issue of it with just the conditions, that actually wouldn't even be necessary.
Sure. With that motion, all those in favor say aye.
Aye.
And those opposed say nay. This item is approved. Our next item is quasi-judicial hearing. It's variance appeal for 4849 Gerard Avenue South. I'll ask one more time, Alex Collas, to give us a presentation. Thank you.
Thank you, Chair Osmond, members of the committee. Before you today is an appeal of a decision of the Zoning Board of Adjustment denying a requested variance to reduce the minimum required interior side yard setback on the north of the property. And this is proposed for construction of a rear addition to an existing single-family dwelling at 4849 Gerard Avenue South. This is in the UN1 Urban Neighborhood Zoning District and the Interior 1 Built Form Overlay District. The appellants are the property owners, Philip and Gail McLaughlin, who were the original applicants for the variance, and they are represented by their architect, Andrews Montney. This comes from the January 4th, 2024 Zoning Board of Adjustment hearing. That this original application also included a requested variance to the rear yard setback, but with this appeal, they have changed the design a little bit. They have eliminated the need for that rear setback variance, and it is just the side setback variance that is the subject of this appeal. This is a survey showing the existing conditions of the property. It's a double lot. It's around 10,800 square feet in area and 80 feet wide. The subject property faces Girard Avenue to the west, and there is no alley access. The principal use and structure of the property is a two-story single-family dwelling, which was originally built in 1913, and they have a detached garage that was originally built in 1916 in the northeast corner. That's a one-stall garage. That existing garage is accessed from a front driveway and curb cut to Girard. They have some other existing site improvements like a deck and a patio, etc. The existing house is set back 2.8 feet from the north property line at its closest point. And this existing house is legally non-conforming to the minimum required interior side yard setback of 5 feet. Here's a photo from the appellant showing the existing conditions of the property in this area between the house and garage. And so as originally proposed, again, just to give the basis for the Board of Adjustment decision in this case, you can see the site plan here showing their original proposal, which required those two variances, even though we're only focusing on the side setback variance in this case. As the members of the committee are aware, all variance requests are subject to three required legal findings, which are derived from state statute and articulate in the city's ordinance. In order for a variance to be approved, including on appeal, all three variance findings need to be satisfied. For staff analysis and recommendation, I'll just summarize briefly by saying the staff recommendation was for denial, and there was the first two findings that we found were not satisfied. That's primarily based on the size of the property. It's relatively large for a low-density residential property in Minneapolis. And we didn't see a unique circumstance that created a challenge in complying with these setback requirements. And then for the second finding regarding the spirit and intent of the comprehensive plan and the zoning code, the comp plan and the zoning code are both written to promote detached garages in rear yards and to discourage attached garages for low-density residential properties like this. And when we have non-conforming structures like this, where it's too close to the property line than what the code would allow today, the existing structure can stay what it is, but the code is intended for new improvements to comply with current zoning code requirements. So that was the basis for the staff recommendation for denial, which was ultimately adopted by the Board of Adjustment. There was some discussion at the board hearing, including the now appellants providing some verbal arguments. The board ultimately voted 5-1 to adopt staff findings and recommendation. Just to quickly show the floor plans for what was originally proposed, and this is substantially similar to what's being proposed today. On the bottom is the main level, and this addition would be for like a pantry addition behind their kitchen, a mudroom and storage area connecting to the garage, and then on the upper level would be bedroom and bathroom. And a couple of elevation drawings showing the proposal. And went through those findings. So now to look at the appeal, the site plan in the bottom, the symbology is a little bit different, but it kind of shows the changes in the design, which are primarily, the changes are limited to the garage, where they have brought the garage further forward on the property and further away from that north side property line. So they've eliminated the need for that rear setback variance and reduced the amount of this proposed addition that requires the side setback variance. And it's the part that is outlined in red is the only portion of this that needs a variance, and so that's all we really need to focus on for this appeal. In the top right is the floor plans that show it's this portion of the pantry that really is the part that needs consideration under this appeal. So again, just to compare those two site plans, on top is what was originally proposed for their variance application, and the bottom is their revisions that they like to present under this appeal. From staff's perspective, again, we can't go back and change the staff report or recommendation in something like this, where now you're considering an appeal of the decision of the board. I will just say generally, the latest proposal as presented under this appeal, again, it eliminates the need for one of those variances entirely, and it greatly reduces the extent of the required variance, so they're moving in the right direction, for lack of a better term. This is generally more supportable from staff's perspective than what was originally proposed. Ultimately, if the committee is inclined to grant this appeal, the committee must find that all three required findings would be satisfied. I would also recommend, if the committee is inclined to grant this appeal, that you include some conditions of approval that we typically include for most variance applications dealing with new construction. One, that they receive approval of final plans from CPED staff, for example, through a building permit application, and two, that they complete all construction work within 2 years unless extended by the zoning administrator. There were, I think, a total of 3 written public comments received for this item, 2 of which were just earlier this week. Those should all have been made available for your consideration. The appellants also previously provided a number of signatures indicating support from many of the neighbors. The appellants are in attendance during today's hearing. This concludes my presentation, but I will stand for questions.
Thank you so much. Are there any questions from the members? I'm going to proceed to open the public hearing. We will first hear from the appellant. Is Andres Matney or representative here? You have 10 minutes to speak. Yes?
If you don't mind a quick clarification.
Sure.
I mentioned that staff can't, I think was the word I used, can't change a recommendation. I think I misspoke and say there are circumstances where we can and have. In this case, we did not, because although it is moving closer to compliance, it's still, when staff is looking at those findings, it wasn't enough to kind of satisfy that first finding in particular about what is unique about the property in creating challenges in complying with the code. But in other instances, staff may be able to change a recommendation if there is a material change in the facts of the matter.
Thank you so much
Apologies.
for the explanation. And, sir, come forward.
Councilmember Osman and Chairman Osman and council members, thank you for taking the time to hear this appeal. As Mr. Koolhaas noted, we are appealing the Zoning Board of Appeals denial of our application. We took their feedback and adjusted the plan, shifting shifting the location of the proposed garage to meet the 5-foot required setbacks, but maintained, as this was not rigorously discussed by the Zoning Board of Appeals, the much smaller setback of 3.2 feet along that side yard. This is regarding the 3 specific requirements, the findings that Alex referenced, the unique circumstances of the property. As he noted, the existing home is located less than 3 feet from the property line, so any sort of addition along there would be non-complying. There is a ordinance in the code that allows for a non-conforming structure to continue with an addition. However, the minimum requirement for that is to be at least 3 feet from the property line. As he noted, the existing structure is 2.8 feet. As this was built in 1913 prior to zoning code, this is kind of an existing condition that is very unique in its location. We've taken and adjusted the addition to be more than 3 feet from the property line to try and honor the intent of that non-conforming requirement, and while still allowing us to work with the existing house and layout, as the kitchen is located in that northeast corner of the structure. As we see here, the kitchen was located here in this northeast corner, so any sort of addition related to the kitchen naturally would want to occur in that location. And down here we see some other kind of contextual photos, and here is a rendering showing the addition that we're proposing. The white is the existing structure, the dark is the neighboring structure, and then this light green shows what is in compliance with the zoning code, and then this dark green is the portion of that addition, also shown dark here, that is we're asking a variance for. As I said, the house is situated less than 3 feet from the property line. The existing kitchen is situated in that corner, and our design attempts to maintain the character of the home and the lot by maintaining the front-facing facade, working off of the back of the house so we aren't impacting, being respectful of the neighbors in terms of stepping ourselves back to that zoning before we get past to their yard, as well as being aware of the existing character of the house and the property and the trees that are on the property. And so as this next image shows, there's a large swath of trees located on the south side of the property that, you know, would be impacted of any sort of move along there versus along this north side property. So that is the unique circumstances. Additionally, there is the spirit and intent, and as I noted, there is the opportunity within the code to continue a non-conforming structure. However, as it was less than 3 feet, that does not apply here. We're asking for following the intent of that by stepping our structure to be more than 3 feet from the property line. We're asking for about a 7-foot long addition off the back of the house that is the length of the non-conforming, 14 square feet. It's a very minimal piece. And then we are not impacting the essential character of the locality. The design, the finishes, the materials, the design is fitting with the existing structure and does not materially impact the adjacent neighbor's property. As you can see, this addition is set back within kind of the wall of the house that we saw in these photos over here. Are there any questions?
No, sir, we don't take questions, but if you're done, I would thank you so much for that. Now we will call others that have signed up. If you haven't signed up, please go see the city clerk. I have Philip McLaughlin. Okay, Gail. You have 2 minutes.
Thank you. My name is Gail McLaughlin, and I have lived at 4849 Girard Avenue South since May of 2010. Our family has lived there, and we worked, as you heard, we worked with the plans that we previously presented, and changed what we would do with the garage and cut out some of the internal, cut that back by a few feet to meet those needs. But one of the things that we heard previously is, why aren't you doing this on somewhere else on your house or on your property? But this is an addition for our kitchen. Our kitchen is on the northeast corner of our house. And if we were to do it, we're not going to build off of our family room and take down a tree and go from the family room through the dining room to get to the kitchen from the pantry. So that's why we're doing it in this. We're hoping to do it in this location. I reached out to many of our neighbors. I showed them our plans. I talked to the 2 neighbors on the north side, south side, and the 3 behind us behind a private alley. Everyone was in full support. The feedback I got was, oh my gosh, this is so great. It improves our neighborhood. You're the type of family we want to stay here and to be here. This is way better than some of the other projects going on in the Lyndhurst neighborhood and the houses that are being built, including, we had a house built next to us last year that maxed out every space on the lot it could. It's a huge house that you see in the pictures. That was built in 2023. And so we have a lot of support of the neighbors. We're hoping you'll reconsider for this one small area, but makes the project flow. And we want to live here for the long term, to meet our current family needs and to meet our needs as we age and stay in Southwest Minneapolis. So thank you.
Thank you. Now, Philip.
Thank you, council members, for giving us the opportunity to be here today. As Gail, my wife, had mentioned, we've been in our home for 14 years. We've been in the neighborhood for 25. This is where we want to age. This is where we want to be. In order for us to stay in the home, we need to make some adjustments. And one of the major things is adding the ability to have the garage attached to the home. We've already had falls in our driveway. My wife broke her leg last winter because of the ice. So be able to walk out to the car and not have the situation where you got to go out in the elements to get to a garage that is so close to the home already, just doesn't make a lot of sense to us not to do that. Our house and garage were built over 100 years ago, and it's 3 inches too close to the property line. I don't know if that's been really articulated. It's 2.8 feet, 3 inches different. If it was 3 inches further to the south, we wouldn't even need a variance. So it's such a small 3-inch difference that we're talking about here. We're not intending to build closer to the property line. It's going straight back from our home, parallel to the house next to us. And as I think we've mentioned, when you look at the property, the trees make a big difference on this south side of the house. Shade the house, we'd have to remove trees to make any type of addition going that way, and we obviously don't want to do that with 100-year-old oak trees on our property. If you could take 2 minutes and stand in our yard, you'd look at this and you'd go, this is crazy that we even need to consider looking at this, because it makes perfect sense for our home. Additionally, I think there was a mention about attached garages that is frowned upon, or we're not looking to put attached garages in our neighborhood. There's 3 houses behind us, one next to us, 2 across the street, 7 houses in all that are essentially touch our property. 5 of the 7 have attached garages. So it seems ridiculous that we're even discussing that we shouldn't be able to have an attached garage in a neighborhood where most of them are.
Thank you.
That's all I have. I appreciate your listening.
Thank you so much.
Thank you.
Is there anyone else who would like to speak? Now, I'll close the public hearing, and Councilmember Cashman.
Thank you, Chair. I have a couple questions for staff on this, if possible.
Sure.
Hi. Okay, so my 2 questions are, one, this appeal is just about the 14 square foot pantry area, not about an attached garage?
Chair Osman, Councilmember Cashman. Generally, that is correct. We are looking at the entire proposal that's being brought forth, but the only part that needs this appeal, essentially needs the variance, is that small portion off of the kitchen. Hypothetically, if they were to remove that portion and submit a building permit application for everything else, that could be approved without a variance or an appeal.
Okay, and then my second question is there a city policy against the attached garages that make it, I heard, frowned upon, and how is it that 5 out of 7 neighbors have it?
I don't know if I would use the exact same language of frowned upon, but there is policy language in the comprehensive plan that encourages detached garages and discourages attached garages for low-density residential properties. I'm paraphrasing. And there are specific provisions of the zoning code, so the actual regulatory document we're using to evaluate new proposals, that provide additional flexibility for detached garages. So for example, if you have a detached garage in the rear of a property that meets certain requirements, meets certain standards, you can be as close as 1 foot to a side or rear property line. But if you have an attached garage as part of the principal structure, it's subject to the same setback requirements as a principal structure, in this case 5 feet sides and rear. So that is more what staff was kind of intending to describe when talking about encouraging or discouraging different types of garages, is that we do have specific provisions of the zoning code that make it easier to build a detached garage. It's not impossible to build an attached garage, and I'm not familiar with all the examples that the appellants are referring to, but would have been proposals that were in compliance with applicable zoning code requirements for an attached garage at the time they were built.
Okay, thank you.
Alex, can you state that if we approve this item, can you state one more time the staff condition that you're recommending?
Yeah, if the committee is inclined to grant this appeal, staff would recommend 2 conditions of approval, which are the same 2 that we include for the vast majority of variance approvals, especially for anything that involves construction. First, a condition that The appellants receive approval of final plans from CPED staff. Usually that's satisfied through a building permit application. And the second condition that they receive or that they complete all construction work within 2 years of today's date unless extended by the zoning administrator.
Yes, Councilmember Chowdhury?
I just wanted to get a clarification on the variance for the minimum required. What is the minimum required, and then how much over is this going?
The minimum required interior side yard setback is 5 feet for a property like this. That can change a little bit in other circumstances, but for the vast majority of properties like this, it's 5 feet. I believe the addition would be 3.2 feet from the side property line. So they're somewhere in the middle there. And the appellants made some references to the fact that they are more than 3 feet from the property line. That relates to some other zoning code provisions about additional flexibility we can have for properties that are too close to the property line currently.
Yeah, thank you, and thank you, Chair Osmond.
Councilmember Ellison?
Often with these decisions, things can seem small, and I'm not going to make a motion on this one because I want to hear from my colleagues. But I know that, there have been times in projects in my ward where we're dealing with whether it's quote unquote minimal changes in the floor area ratio or whatever, where I would love to be able to make exceptions to these rules. But, and if we don't like the rules, then we should change them. I'm inclined to stick with staff recommendation here. I won't make that motion because, it's not my ward, not my part of the city, and I don't feel that strongly about it, but I just want to, us to be thinking about that as we're making these decisions. And so that's just not to say that I wouldn't vote for, approving this and placing the conditions, but just thought I'd throw that out there. If we don't like the rules, we should change the rules. But I'm weary of us making decisions that might feel arbitrary. And if my colleagues don't agree that approval of this would be arbitrary, I'm open to being persuaded. But just thought I'd put that out there.
Thank you, Councilmember Rainville.
Thank you, Mr. Chair. So to my colleagues, I do approve, I will vote to approve this appeal. In fact, I'll make the motion to approve the appeal. To the applicants, I have an attached garage. I find the comfort in the safety that provides, both from the weather and from the craziness that happens at night. It makes my wife feel a lot more comfortable, as well as myself. And I thank you for investing in your house and your desire to stay in the community as you age. It's expensive to remodel homes. I can only imagine what this costs. But and I appreciate the professionalism of our staff. This is my motion is no reflection on your ability to follow the rules. That is what you do so well. But this is such a minor thing that it's good to decide on the side of our residents who are invested in our community. Thank you.
Councilmember Jenkins.
Thank you, Chair Osmond. I too am going to be supportive of this appeal. And, I don't want to put words in staff mouth, but it sounds like the applicant has really made some changes to be able to comply with the regulations, and they've come down to this one last variance, which is a very small impact. The neighbors all seem to be supportive of this, including the direct neighbors to the north and south. And so consequently, I think that, they have met the majority of the goals that we set forth as a city. I don't think we necessarily need to change the rules, which is why we sit here to be able to to have impact on individual cases, right? If we just did everything by the rules, there would be no need to have this body. So I will be supporting. I wish I had an attached garage. I would probably use my garage a lot more, but consequently I don't.
Councilmember Chowdhury.
Thank you, Chair Osman. I just wanted to take a second. I know that Councilmember Palmisano is here sitting through our committee, and I would really appreciate, since she sat through all of our business today, if she wanted to kind of share some of her perspective and maybe speak to some of the concerns that Councilmember Ellison is bringing, if the chair would allow.
Yes.
Well, I wasn't planning to speak this afternoon, but yeah, I have been here and for this item because my constituents are here looking to improve their home. I do land in the area of supporting this variance. I don't think that I would have supported their first project. I would see it as a skyway in the 13th ward. I worked diligently about 8-9 years ago to make 16 zoning text amendment changes to these, to how we can build and modify 1 to 4 unit dwellings. Those were all very carefully considered, and it is important, and something I have been speaking with some of my newer colleagues about is the importance of being able to see through backyards and the value that lends. And this does actually make the points needed for new projects. It does make attached garages more difficult to meet. Now, this is a very large lot. This is not a problem with meeting ratios. They're not, they're gonna have enough windows. So while I would not have been in support of their first crack at this version 1, I wouldn't have been able to, because I literally changed the rules to make sure that we were further away from property lines. These modifications, I think, are very reasonable. It also does not set any precedent for any future kinds of work. There are some unique aspects of the properties on this block in that they literally face their front yard is the alley and the garages of those other homes facing Minnehaha Parkway. And for that, I think this is a little bit of a unique situation with where people place their garages. So thanks for the opportunity to speak. I guess since the public hearing is over, I can say I am certainly in favor of this variance and granting it. So thanks for the opportunity.
All right, thank you. Seeing none, with Councilmember Rainville's motion to approve the appeal with, I would say, the 2 conditions of the staff. All of those in favor say aye.
Aye. Aye.
I'm sorry, Councilor, do we require a second on these motions?
Attorney, city attorney.
Mr. Chair, to Councilmember Jenkins' question, we do require a second, but it appears that it's there. I mean, if the second is given by unanimous consent, it's
I'll
fine.
make sure next time call the second.
Thank you.
I'm sorry, one more time. All those in favor say aye.
Aye.
And all those opposed say nay. The item has been approved.
I was just saying that in this matter, I would request that you request or direct staff to prepare findings reflecting your decision. Thank you.
And I will direct the staff and the city attorney to find draft finding for this. Thank you. And our final quasi-judicial hearing is an appeal regarding the property at 400 Prospect Avenue. I will ask Aaron Kay to give us presentation.
Thank you, Chair Osman, committee members. I am still Erin Kay, and I'm a planner in the Historic Preservation subsection of the Department of Community Planning and Economic Development. I'm here today to present an appeal of the Heritage Preservation Commission, or HPC's, denial of a demolition of historic resource application for the property located at 400 Prospect Avenue. I was planned to start by telling you this is a very complex appeal, but I think that all of our items today have had their own complexities. So I will begin with an overview of the process for this type of application, summarize staff findings and the decision made by the HPC, address the appeal, present revised staff findings, and summarize public correspondence. I think it's important to start with the ordinance definition of the term historic resource, which is shown here. And so if I can translate it for you, essentially, a historic resource is a property that has significance and may meet at least one of the designation criteria, which I will show later in the presentation. So although a historic resource is believed to meet the criteria to be designated, it has not been formally designated by City Council. This proposed demolition came to CPED Historic Preservation staff via a wrecking permit application. Our team reviews all wrecking permit applications in the city to confirm whether or not the property proposed for demolition is a historic resource. This is a desktop decision made by staff based on initial research. If the property is a historic resource, then the applicant has to submit a demolition of historic resource application before we can approve demolition. This type of application allows for further research analysis and a public hearing process. The subject property is located at 400 Prospect Avenue in Tangletown, and it's across the street from the Washburn Park Water Tower, which is an individual landmark. So here you can see an aerial view of the property's location. And here's a picture of the front elevation. The house was built in 1926. The applicant is proposing to demolish the house that is currently on this property. The property owner is planning to subdivide the lot into 2 residential lots and build 1 single-family dwelling on each lot. The proposed new construction will request development approvals at a later date and is not part of this application. During staff's review of the wrecking permit application, staff determined that the property was a historic resource because it is located within a potential historic district. We use the term potential because this area has been determined to have historical significance, but it has not been officially designated as a historic district. For a demolition of historic resource application, staff analyzed historical significance, architectural integrity of the property, whether demolition is necessary to correct an unsafe or dangerous condition, and whether there are reasonable alternatives to demolition. For the application heard by the HPC on December 12, 2023, staff analyzed both the individual property and the potential historic district. Staff conducted research and analyzed whether or not the property at 400 Prospect Avenue met any of the designation criteria listed here. Staff found that the property at 400 Prospect Avenue is not individually listed in or eligible for listing in the National Register of Historic Places. Staff also found that the property does not appear to be eligible for designation as an individual local landmark under any of these criteria. Staff also found that the potential historic district has historical significance and that demolition of the subject property will impact the historical integrity of the potential historic district. And additionally, to address the 2 required findings of this type of application and based on the submitted materials from the applicant, staff found that no unsafe or dangerous conditions have been proven to exist on the property. And staff also found that there are reasonable alternatives to demolition, considering the significance, integrity, and economic value or usefulness of the existing structure. The HPC voted to adopt staff findings, deny the demolition of historic resource application, establish interim protection for the potential historic district, and direct staff to initiate a designation study of the potential historic district. The applicant appealed the HPC's decision. The appeal challenged the ordinance language and the validity of the HPC's action to deny demolition, and also their action to establish interim protection and direct staff to initiate a designation study of the potential historic district. Upon receiving the appeal, staff consulted with the City Attorney's Office. The City Attorney's Office determined that the HPC followed an incorrect interpretation of the current ordinance relative to this process. The City Attorney's Office advised that the potential historic district should not be taken into consideration for this application, that interim protection does not apply to any of the properties in the potential historic district, and that a designation study of the potential historic district was not correctly initiated. For the decision before the committee today, you may only consider the demolition of 400 Prospect Avenue. The potential historic district is no longer under consideration. In light of the City Attorney's Office determination, this is one of those unusual circumstances where staff would like to present revised findings and a revised recommendation for your consideration, as shown here and in the memo you received in the packet. So because the potential historic district is no longer relevant to this application, findings number 4, 5, and 6 are not applicable. Based on findings number 1 and 2, which state that the property is not individually listed in or eligible for listing in the National Register of Historic Places, and that it does not appear to meet any of the local designation criteria. The subject property is not considered a historic resource anymore. Therefore, CPED recommends that the Business Housing and Zoning Committee adopt staff findings and grant the appeal by Tim Helene of Helene Company of the Heritage Preservation Commission's December 12, 2023 denial of a demolition of historic resource application to demolish the property located at 400 Prospect Avenue. Given the complexity of this project, staff have sent additional communications about this project to the public beyond what is required by ordinance. We sent a letter to all property owners in the potential historic district at the end of December, and also sent the notice for this hearing to the same mailing list. Staff would like to acknowledge Ward 11 and the Tangletown Neighborhood Association for their various communications to residents about the project as well. Staff in Ward 11 also presented on the project at the Tangletown Neighborhood Association meeting on January 16, which was attended by about 30 people. Since the HBC meeting in December, staff have also fielded phone calls and received, I think the current total is 44 public comments, which have been shared with you. Many neighbors and residents are passionate about the historic character of their neighborhood and oppose demolition of this property. Staff has received one comment prior to the HBC hearing that supported demolition. This concludes my presentation, and I'm happy to stay for questions. The applicant or the appellant is Tim Helene, and the property owner, Dan Olfelt, are also here and would like to speak to the appeal.
Thank you so much for the presentation. Just a reminder that we have to wrap it up by 4:15. So I will limit the time of public hearing. For now, I'm going to proceed to open the public hearing. And we will hear the first for appellant, Tim Helene. And you have 10 minutes to speak.
But you don't have to take the whole 10.
Thank you.
My name is Tim Helene. I am a building contractor, and I did file the initial application and the appeal. But I am a building contractor, and I would like to cede my time to the property owner with your permission.
Yes.
Council members, thank you for taking the time to hear what we have to say. As Tim said, I'm Dan Olfelt, and I, along with my wife, Allison, own the property at 400 Prospect Avenue. We are relieved and grateful that the staff has come to the same conclusion that we did, and we hope that you will follow the recommendation. The staff memo follows the original staff report presented in HPC to find that the property is not found that the property is not a historic resource because it is not listed or eligible for listing in federal or state registries, and it is not located in a historic district. We understand that after finding the property is not a historic resource, the HPC was required to allow us to proceed with the demolition permit without further consideration about the condition of the property or whether there were alternative uses to demolition. We are again grateful that the staff reached this conclusion, and our attorney will address this further. We nevertheless want to let you know that we did consider alternative uses and the building condition when we purchased the property. We purchased the house as investors, knowing the condition of the existing structure and loving the character of the neighborhood. We also knew that the neighborhood was not, and still is not, a designated historic district. The existing home was and is still in extremely rough condition. The pictures in the initial staff report show the condition of the house as we purchased it from the previous owner, complete with its contents that we had to clear out ourselves. The plaster was falling off walls and ceilings. The roof was leaking. There were years of water damage, rotting, multiple safety and code violations, and a cracking foundation. My contractor, who you just met, estimated the cost to renovate this property at over $350 per square foot, which is $100 a square foot more than the cost of building a new home or two new homes. And even with the extra expense, the existing home would not meet current energy standards and codes, nor resolve any health or safety concerns like lead paint or asbestos. The existing house is built on 2 platted lots, like Aaron said, which creates an opportunity to replace it with 2 new homes that will fit the character of the neighborhood, and 2 new families will get to enjoy the winding roads of Tangletown. This is also consistent with the city's goals to increase housing opportunities in our existing neighborhoods. Again, we are grateful for the staff recommendation and hope that the City Council will follow it. Our attorney, Diane Golodowicz, will address the specific findings. Thank you.
Council members, thank you for your review and consideration of this appeal. My name is Diane Golodowicz, an attorney with Stinson LLP here in Minneapolis. I am counsel for Dan and Allison Ofelt. The Ofelts respectfully ask that the members of this committee overturn the December 12th decisions that the commission made and grant the Ofelts demolition permit. The commission properly found that the Ofeldt property is not an historic resource because the property is not designated or eligible to be designated as a landmark and is not located in an historic district. These findings were not appealed. The commission's findings should have stopped here. Per section 599.480 of the code, a commission finding that a property is not an historic resource requires the commission to approve the demolition permit. Instead of approving the permit, as the code requires, the commission improperly imposed interim protections on the entire Washburn Park neighborhood. We appreciate that the city attorney and the HPC staff have recognized their error and that staff has since revised its recommended findings and now recommends that the council grant our appeal. For the record, and certainly without arguing with the current staff recommendation, I will state our reasons for the appeal and request a modification to the recommended findings in this appeal. The basis of our appeal is that the Washburn Park neighborhood has not been nominated as a historic district, not at the time of the commission hearing, and it's still not nominated at this time. The commission did not and does not have the authority to impose interim protections on the Ofeldt property and all of the properties in this area before the district is nominated. This is not just a technicality under the code. Chapter 599 of the Minneapolis Code provides a process for nominating a historic district. That process allows for public notice, consideration, debate about the benefits and burdens of being in a designated historic district. And that process allows for public dialogue on this issue. And once the city, with public input, has determined that designation may be worth studying, it is fair and reasonable to impose those interim protections during the study period. Imposing interim protections before the city makes that initial determination unnecessarily and unfairly burdens every property owner and city staff with historic review of every application of a building permit for commercial and residential construction, not just demolition for new construction. Because the Washburn Park neighborhood has not been nominated for designation as a historic district, city staff has properly withdrawn its recommendation and findings related to interim protection. And because the commission findings, finding that the property is not a historic resource was not appealed, we therefore ask the City Council to adopt the staff recommendation and grant our appeal and direct the city staff to proceed with the demolition permit. One point of clarification about the revised findings from the city staff. With respect to revised finding number 3 regarding unsafe and dangerous conditions, and finding 7 regarding reasonable alternatives to demolition, these findings are not relevant to this appeal. These specific findings relate to the demolition of an historic resource. Here, the commission made findings that the city staff recommends that you uphold, that this property is not an historic resource on its own. So these specific findings do not apply. So we respectfully request that these findings be stricken as well. Thank you very much for your review and consideration.
Thank you so much. And next, we will hear from others who sign up to speak. I will give you each 1 minute. And as I call you, if I leave your name, please let me know. The first person is Sarah. And Sarah Barr.
My name is Sarah Bartle. I live at 146 Prospect Avenue. Members of the council, I'm here to speak on behalf of my concerned neighbors, your constituents who are represented by those standing before you, along with many others who could not attend this meeting. We love our neighborhood and we love our city, and together we would like to put forth the following points for the council's consideration. And this will be continued by other speakers if I can't make it through. First, our neighborhood has relied on the city's findings. Prior to the December 12th meeting with the HPC, we received Erin Key's report recommending denial of the demolition permit based on what she had held out as valid reasoning. This was adopted by the HPC when they heard her findings. It was only on January 16th at a Tangletown neighborhood meeting we learned that the city attorney viewed this entire process differently. These findings were written in a memo dated January 19th, but weren't published until just a few days ago. We have relied on the city this entire time, and by the way, the city's website still says the study can begin at the HPC's denial of a demolition permit. Erin has also shared historic neighborhood studies have taken place based on the denial of demolition of one property, for example, 4632 Emerson, which led to the Lyndhurst Residential Historic District. Thank you.
Thank you so much. And next, Jay Richardson.
Yes, good afternoon. Jay Richardson. I live at 1 West 50th Street or 5000 Nicollet. It's the corner of 50th and Nicollet. I've been in the neighborhood for 38 years. It's a beautiful historic neighborhood. We live in a historic house designed by Harry Jones. I'm a retired architect. I had the pleasure of designing the fire station at fire station number 27 on Nicollet. And this house is one of 4 beautiful Mediterranean-style homes in a row. And yes, it has some rough aspects to it, but that house could be salvaged and restored. And we're all concerned about environmental matters. The greenest house is an existing house, an existing building. You save all of that wrecked house from going into the landfill, and you save all the new materials.
Sorry, sir.
That wraps it up.
Thank you so much. Yep. Leslie Legg.
Hello, my name is Leslie Legg. I live at 5025 Belmont Avenue South. I've been a Tangletown resident for 21 years. I am interested in rehabilitating the home at 400 Prospect Avenue. I am a qualified buyer. I have helped to restore 2 historic homes in Minneapolis while living within them with my family. I don't flip houses for a living. I just believe in investing in homes with character so that they can live on for the next generation. On January 16th, after a neighborhood meeting, we asked the Oldfelts if they were still willing to sell the property. They said yes. The price discussed was $450,000. We asked if we could tour the home with a structural engineer to assess the roof and foundation. The Oldfelts seemed amenable to that request, and we exchanged phone numbers. We reached out to follow up, but we have not heard anything since. If the Oldfelts are willing to sell, we are confident that buyers who love the home will come forward. Please deny or at least delay the demo permit for 180 days.
Thank you so much. Sarah Muskie.
As you've heard today and through many emails from neighbors sent to your offices, your constituents want to save the historic property that sits directly in front of a nationally designated historic landmark, the Washburn Water Tower. Both the owners and the developer are residents of Edina, not Minneapolis. They are not your constituents, and they do not intend to become your constituents. The Tangletown neighborhood is not opposed to the big picture concerns of our city, namely density and affordable housing. However, splitting this lot and building 2 $1 million to $1.2 million homes serves neither of these goals. Any argument the owners or developers have on these issues rings hollow. I ask the committee to remand this subject back to CPED and HPC so it can be studied properly this time. Thank you.
Thank you. Diane Glatowicz. Oh, thank you. Ashley Ilfane. State your name, sir.
Yes. Ashley Ilvanen, I've talked to you before earlier today. I'm an architect, principal of a firm in Minneapolis, and that works in this community. I live at the corner of southwest corner of the potential Washburn, what is still the potential Washburn Park Residential Historic District if it were so nominated. I live in a beautiful J.W. Lindstrom house. There's tons of these things in the neighborhood. Though these are not classified as historically significant structures, they're important structures in the neighborhood and make up the urban fabric. The house in question is, as a gentleman architect that has spoken before me, the foremost tenet of sustainability in architecture is to reuse what you have. House was bought for $400,000. Houses sell for $800,000 in the neighborhood. There's plenty of meat on the bone to restore that house.
Thank you so much. Next, Mike McCabe.
I'm Mike McCabe, and I live about 7 houses away from the property in question. I am in support of denying the demolition of this house. You guys have to see it. You have to walk that neighborhood. You have to see how everything looks in that neighborhood. And what their contractors are going to do is cut it up, chop it down, put up something that does not fit with the neighborhood. Yeah, it's a double lot. A lot of the properties there are a double lot. I've been in the house. It's structurally sound. It's got nominal wood, original dimensional lumber in this thing. It's rough. Doesn't mean you can't fix it and make it look pretty like a lot of us have done in our neighborhood. Deny this thing, put it on the table for another 180 days, study it, make it fit the neighborhood instead of some greedy contractor making $1 million just overnight on this thing. And they've had it for a year. We've had opposition to this for a long time. Look at all the people here. You should listen to us.
Thank you so much. Next, Todd Smith.
Good afternoon, council people. My name is Todd Smith. I'm a resident at 20 West Elmwood Place in the Tangletown neighborhood. I support the revised staff position. There was no historic nature to this house, as has been proven. It seems unfair to have someone purchase something and then give them a higher bar that they must cross at a later date. Further, going back to a comment you made, Councilperson Ellison, at the last agenda item, if there's rules we don't like, we should change them. Historic districts are fine. Potential historic districts that have gone on since 1985 and never been recognized are being utilized as a tool that's anti-development. Thanks for your time.
Thank you so much. Tim. No last name. Is Tim here?
Chair Osmond, I believe that was the appellant.
Okay, thank you. Next, James Weston.
My name is James Weston. I own 4700 Pillsbury. It's a duplex in the Tangletown neighborhood. And I am here in support of the demolition. I believe the Historic Preservation Committee has gone too far with this process, where a potential future historic district is kind of this term that they made up. Could be any home in the entire city of Minneapolis could be in a potential future historic district. And I wouldn't want a historic preservation committee telling me what to do with my property if it wasn't of any historic value or in a current historic district. Thank you.
Thank you, James. Next is Steve Dahl.
My name is Steve Dahl, and I live Gladstone Avenue, which is, well, if you imagine it, the water tower is up here. I'm at the bottom of the hill. If it lets go, it comes right into my living room. So we see it every day. The water tower is a great landmark. It's a historic, National Historic Register, and it's important that this symbol is continues to be in a neighborhood that is of the same vintage and the same quality of that historic water tower. It was built. The home was built in 27. The historic, I think it was 27, either 31, but the tower, I guess, was built in 31. It created a classic home designed to last a long, long time. It was built during a time when quality materials, someone mentioned the 2x4s, real 2x4s, and real plaster. My home is real 2x4s, that's real plaster. I wouldn't give it up for anything. That was a quick minute. Thank you for the chance to address you.
Thank you so much. I see that was the last person. Is there anyone else who would like to have a minute? Go ahead.
Spencer Bartle, I too live on Prospect Avenue. I'll pick up where my wife Sarah left off. She was speaking about the property at 4632 Emerson, which led to the Lyndhurst Residential Historic District. That was one house that led to a study. Had the City Council provided different direction, we would approach this differently. Number two, CPED did not make sufficient findings on criteria 3. Our neighbors appreciate everything that Aaron has done. However, much like our neighbors, Aaron believed that exploring the neighborhood's historic potential could be a way to settle the issue of whether 400 Prospect should be demolished. HPC never challenged her. When she considered the 7 criteria, she focused more on the neighborhood than the house, and she should be allowed, with the city's attorney's new guidance, to consider just the house and make appropriate findings. Third, the council should not hear new evidence from the appellant, and it sounds like that's not going to happen, which is great. Finally, this should not be decided today. Again, considering the extremely new guidance from the city attorney and our reliance on previous communications by the city over the past several months, this should be either heard again by the HPC or continued for the council to consider when everyone has an opportunity to submit evidence on 400 Prospect and whether or not it should be demolished. Thank you.
Thank you so much. Last call, is there anyone else who would like to say something? Yes.
Thank you, council people, members, excuse me. My name's Allison Olfelt. I'm the co-owner of this house. And I just want to quickly say that we love the town. We love the area, the curving roads. We aren't big developers coming in to make a big profit. We want to improve the neighborhood and see potential there. The findings of the staff, they did consider the house already. So what you're being asked to do, to delay, to consider longer, has been done. That study happened on the house. And yeah, I just thank you for listening to our concerns.
Thank you so much. And now I will close the public hearing and ask if there's any comments or questions from the members. Councilmember Allison.
Thank you, Chair. I want to recognize that the staff's original recommendation was based off of an assertion that ended up not being real, and so I think that is I'm trying to look at is historic designation there? We're being told that it's not there, and so to me, as much as it's difficult, we've got folks who care about their neighborhood who are showing up to give testimony here. It feels to me that the appropriate action is to allow for the demolition, and so, and I believe that would mean granting the appeal. So, I'm going to go ahead and make that motion. I'm again open to discussion, but that's how I'm reading the facts in front of us, and so that's what I want to move.
Thank you so much, Councilmember Jenkins.
Thank you, Chair Osmond. Yeah, I empathize with the neighbors and having initially one determination and then subsequently staff coming back and recognizing that after studying this matter that it is not, in fact, a historic home and or neighborhood. And as we saw today, historic designations require a lot of resources and time in order to restore them if they are, in fact, historic properties and or in historic districts. one of our biggest challenges in the city of Minneapolis is the lack of housing. And it seems to me that this project would double the amount of housing in that neighborhood. And so subsequently, I'm inclined to be supportive of the staff's recommendation.
Thank you so much. Seeing no one else, Councilmember Allison's motion to approve the demolition with revised finding, staff finding. I will ask a second. Second. Councilmember Jenkins, second. I'll ask City Clerk to call the roll. Or all those in favor say aye. Aye. All those opposed say nay. One abstain, and that item has been approved. Thank you so much for coming and for your comments. And now we are gonna go on our last item. Oh, Councilmember Allison.
Thank you, Mr. Chair, and I am noticing the time. You made a comment earlier in the meeting that we have to be out of this room by 4:15. I know we have a presentation on an item, and I don't want to cut staff off. I see that they're here, but considering the nature of the item, the discussion that we had last term about the item, I don't know the length of presentation, but I feel like between the presentation and the potential discussion, I don't know that we have enough time to take this item up, and is wondering if my colleagues would entertain a motion to move this to COW, Committee of the Whole. This was an issue that the whole council was interested in, has an opinion on. If staff is amenable to it, if committee members are amenable to it, for the sake of time, I would like to move this presentation to COW, with all due respect to staff being here. Apologies. I just don't know that we have the time to take this up in an appropriate way.
Second, thank you so much. I am supportive of that, and I see the author of Councilmember Wansley being here. If she's okay also with that. Yep. I would like to ask you to Councilmember Allison's motion to refer this item to COW. All those in favor say aye.
Aye.
All those opposed say nay. The presentation will take about 30 minutes.
Mr. Chair, Councilmember Jenkins, there's a meeting of the Heritage Preservation Commission that begins at 4:30 with noticed public hearings.
Okay, that item is approved. And seeing no one else, seeing no further discussion before us, with no objection, I will declare this meeting adjourned. Thank you so much, all of you.